Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I want to talk to you about the law in relation to somebody who's pregnant or on maternity leave and redundancy. Now, I can understand why often employers feel that because of the Equality Act and the ability for somebody who is pregnant or on maternity leave to claim sex discrimination, that they feel that they can't go there when it comes to a redundancy exercise, or that they must treat that person with kid gloves. That's not actually what the law says, and it is entirely possible to include somebody who is on maternity leave or pregnant in a pool of selection for redundancy if there is a genuine redundancy situation. Now, when it comes to things like consultation, you'll have to think about how you include that person if they are off work. Things like the keeping in touch days that you're able to use under the maternity leave legislation could be useful to ensure that that person comes in and is included in the process as much as anybody else. You are going to have to take care not to penalise the pregnant person or the person on maternity leave when it comes to the assessment process or the selection criteria that you may be using to decide who stays and who goes. So, for example, you can't penalise them for their absence in the same way as you wouldn't penalise somebody with a disability in relation to time off. You're going to have to think carefully about the criterion that you use. So to give you an example, one of the big law firms got into trouble a few years ago in a situation where they were scoring the employees in relation to a particular issue within the business to do with how clients were charged and how quickly they turned around payment from those clients. The person who was on maternity leave was automatically given the highest score because it was felt that during the assessment period that they were looking at, she hadn't been in work, so it wasn't fair to look at her actual statistics. They would give her the benefit of the doubt and they'd give her the highest score. In that circumstance, the gentleman who scored more lowly claimed that that was directly discriminatory against him, and he was successful in that. So you do need to think carefully about scoring issues, and that may be an area where you want to take advice. If you go through the process and the person who genuinely does score the lowest is the pregnant person or the person on maternity leave for fair objective reasons, then it may well be that you have a fair redundancy. If the person has already triggered statutory maternity pay at that point, then your obligations in that regard will continue. You will still have to make those payments even though you are making that person redundant. What a lot of employers choose to do at that point in time is to make a lump sum payment rather than continue paying it every week. Where you have selected a pregnant worker or somebody on maternity leave for redundancy, there are special obligations when it comes to looking at alternative employment. Now, you've got the general duty in terms of unfair dismissal to look at alternative employment for people when it comes to following a fair procedure anyway. But for somebody in this special category, there's Regulation 10 of some 1999 regulations dealing with parental issues, which creates a special obligation on the employer. And the way it works is this: if you've got a suitable vacancy for that individual, then you are expected to put that worker into that post. So if you have perhaps only one vacancy and 3 or 4 people who have been made redundant, then there's always the possibility that that pregnant worker or the one on maternity leave, if you like, trumps the other people. It's quite an unusual regulation. Not everybody knows that it exists. Under the changes that are coming in 2015 dealing with shared parental leave between mothers and fathers, fathers will then get similar rights as well. So it would be interesting to see what employers are going to do in circumstances where they've perhaps got 2 people and only 1 position. How are you going to decide between the two. Obviously, you'd have to choose some fair and objective basis, perhaps scoring again between the two to decide who gets that alternative position. But potentially, it's those parents who would trump perhaps a single worker who doesn't have family responsibilities, and that's just the way that the law is going. If you've got any questions on today's session, please do send me an email. It's adenton@refreshinglawltd, all one word, .co.uk. Thank you very much.